have 4 experiential modules that I have put in the course and spread them throughout the entire semester, because of course it requires additional out-of-class work by the students. So to be fair, I wanted to make sure they weren't concentrated at one time, but it was important that I taught the doctrinal material first in my mind. In the course of events, I teach, basic marriage requirements first, and then I teach divorce. So after divorce, we have the first experiential module, and that is interviewing the client. So on that day, we bring in practitioners who conduct an interview from the moment the client walks in the door. And we really simulate the whole thing, the table, the Kleenex, the plant. The client walks in. They learn just seeing someone greeting the client and see how an interview is conducted about a woman who wants to get a divorce. And so in preparation for this interview, I hand out to the students what I call Module 1, that talks about learning objectives and what they should know about interviewing a client and how to think about preparing for the interview. It's a packet of information. At the same time, our skills department is offering skills specific to interviewing the client that goes into more in-depth about interviewing and allows the students to conduct the interview. One of the other things that I wanted you to notice is that the lawyer gets in and asks difficult questions. I think that's one of the hardest things. She's going through a divorce, she's coming in, she's kind of embarrassed. I mean, think about how you are when you first go in the doctor's office. It's not all that comfortable. She doesn't end up in lawyers' offices very often. So they're building the trust, and then you have to move on and get some of the answers that you need. The second module comes about 2 weeks later. And that module is when the students have to turn in the divorce petition. And they have to turn in the divorce petition that they have drafted based on that interview, and the practitioners come back. The same practitioners come back who saw the interview and now come in and present what their divorce petition would have looked like. We have a PowerPoint presentation that really goes paragraph by paragraph, explaining why certain things are pled and explaining strategy, why I would have put this in, but at this point I would not plead, these specific things. And at that point, the students have on their own, which I will tell you there is some discomfort in this process, but in the end, the students always say, it was hard for me starting without anything, and I send them to books. In the paperwork I give them before the module, they have resources to look for, form books, treatises to read, but I do not give them a sample divorce petition. And this is something I did struggle with for a while because, of course, they want the sample divorce petition. But I want them to know they can do it without a document that someone hands them that they're going to sit and copy. In this drafting exercise, it's not just a divorce, it's drafting, an eviction proceeding. It's drafting other types of civil litigation that I think can make them realize they need to tell the story through that document. And so they turn in that document on that second experiential module day, and they bring one with them to class. And after we go through it, the floor is open for questions to the practitioners. The third module is still carrying this case forward. So now we have filed the petition for divorce, and along with that filing, I also have them draft a rule to show cause to set the matter for hearing, to set specifically child custody and child support for hearing. And in this child custody and child support hearing, I take volunteers to represent mom, dad, the grandmother who's seeking visitation, and the children. And what is going to happen in this third module is that the practitioners are coming again, but this time they're acting as judges. And they're sitting as judges, and they present child custody arguments, no evidence because of the time constraints, but just arguments setting forth the standard of review, the burdens of proof, rather, the law, and the facts, because As we know, that's often a difficulty for students really developing the facts and explaining the facts in a coherent manner. And so through this process, while I can't involve the whole class in making the arguments, the students get to participate or witness other students making these arguments and see how a judge would interact in this type of situation. And then the students ask questions to the other students and get feedback on how they would handle themselves in this type of custody situation and how they would respond to some of the questions that naturally they don't know all the answers to, because this is a simulation. And so the judges will ask a question that they don't know, and they need to know how to respond to that too, because that's going to happen in real life. So we often discuss that issue during that module. My last module, Experience 4, is a visit to a family court. That's not done in the classroom. That's done outside of the classroom. And the students have to visit. I have a relationship with 3 of the family court judges in Orleans Parish who know about this process, welcome the students in, usually take them back to chambers as long as it's possible at the time that they come, talk to them about litigating in family court, and the students write a 1-page reflection paper, which I enjoy reading like no other, because I ask them to be honest. What do they think about it? And they really talk about, I can't believe how much we have to wait. I can't believe how much it costs to park. I can't believe how many people, here's was a big one, how many people don't have lawyers. And it's eye-opening to them, even ones who have been in court before, to really sit and think about what these litigants are going through. I would absolutely recommend integrating this into your course, because it really does elevate family law to a completely different level. For me as the professor and for the students, it's very doable, specifically when you get the practitioners involved. There was a lunch meeting that I remember talking about the facts. Here's the typical fact scenario we have, and they went through it and we drew up the facts. It's developed over the years I've been teaching it. Now we have a deposition transcripts. We have emails from the client that we can provide as they prepare for the custody hearing, as they prepare for their divorce. And so you have people who are invested, who do this every day, suggesting what type of facts to include and what type of skills that the students will need in entering this practice.